The insights in this briefing are drawn from Chapter 7 of Professor Richard Boateng's Information Technology Policy and Strategy. Global data protection frameworks like GDPR and HIPAA strictly dictate modern IT operations. They enforce severe financial penalties and directly restrict how enterprise artificial intelligence systems are built and deployed. Relegating data privacy to a post-deployment checklist creates systemic legal and financial vulnerabilities that can halt modern enterprise operations. The General Data Protection Regulation, or GDPR, is a sweeping extraterritorial law protecting all personal data belonging to European Union citizens. It mandates strict compliance, including a 72-hour window for reporting data breaches. By contrast, the Health Insurance Portability and Accountability Act, or HIPAA, is highly specialized and U.S.-centric. It focuses exclusively on protecting health information, allowing a longer 60-day reporting window for significant breaches. This matrix highlights the financial exposure. GDPR fines reach up to 20 million euros, or 4% of global annual revenue. HIPAA relies on a four-tiered civil penalty structure, capped at $1.5 million annually per violation category. HIPAA also carries severe criminal penalties. The Department of Justice prosecutes cases involving malicious intent or the sale of health data, with punishments reaching 10 years in prison. An organization's legal and financial risk profile is directly defined by two variables: the specific type of data it stores and the geographic origin of that data. These regulations tightly restrict AI development. Developers cannot scrape data infinitely. Every piece of training data must be lawfully justified, and collection strictly minimized to its specific purpose. AI architectures must also satisfy data subject rights. The system must allow individuals to access, correct, port, or completely erase their personal data upon request. When machine-driven profiling impacts an individual's legal status, organizations must provide human intervention and prove the algorithm is free from discriminatory bias. Artificial intelligence can no longer operate as an opaque system. Explainability, transparency, and human intervention are legally mandated design requirements. GDPR's extraterritorial reach creates geopolitical friction. When European data is processed in Africa, it retains its GDPR protections. This creates a dual standard, giving EU data stronger legal shields than local African data, while placing high compliance costs and market entry barriers on local tech startups. Moving AI data across these borders requires strict legal engineering. Transfers must pass through compliance checkpoints utilizing standard contractual clauses or binding corporate rules. Geographic laws intersect with strict industry requirements. Healthcare AI, for example, must navigate both national data laws and sector-specific protocols for anonymization and medical device compliance. Deploying an AI system globally requires a multi-layered legal strategy to simultaneously clear physical borders and cross-industry regulations. GDPR establishes the global baseline for individual data control, while HIPAA provides the blueprint for specialized protection when handling sensitive datasets. To operate legally and effectively, enterprise IT strategies and AI policies must hard-code transparency, fairness, privacy, and accountability into their foundations from day one.